Chapter 11, this chapter is going to discuss contracts and legal terminology. It's going to go over real estate, and then it's going to start getting into real estate contracts more specifically. But first, we're going to talk about contracts, general contract law, and then we're going to put it, gear it towards real estate contracts, and we'll go on from there. There's a lot of terminology. We're going to go about legal processes, what happens if somebody breaches a contract, statute of limitations, what are the required elements that have to be in a contract. We're going to go over a lot of these issues in this chapter. So this chapter is going to cover a lot of information, a lot of new terms, terminology, and you will get quite a few questions from this chapter on your state exam, but you'll also get them on your school. So without further ado, let's get the ball rolling here. Just jump into it today, okay? Y'all on board with me?
Yeah.
Yeah? Say, yeah, Vic, let's do this. Woo, woo, woo.
Yeah,
Yeah.
whatever you said.
Bigfoot's donuts?
All right. So, so chapter 11, real estate contracts. I already went over all the things that we're going to go over in this chapter, so let's just jump into it on page 168. We're just going to start right off the bat with what are the 4 essential elements of a valid contract, and it would help if I shared that slideshow with you. Can you guys see that? There you go. So what are the 4 essential elements of a valid contract? All right, so the 4 essential elements. Well, let's start off with competent parties. You have to have competent parties involved. You can't have a contract with people that are not of sound mind or legal age. Legal age is 18, right? And they have to be competent parties. They have to be sound-minded, sane, sober adults. They can't be insane. They can't have mental disease or defect, Alzheimer, dementia. You can't be under contract with somebody who does. How are you going to sign contracts with people who are not sound mind? Contracts with people under 18 are voidable contracts. All right, we'll get into that as well. Now, if we go to the book, let's just highlight the title, Essential Elements of a Valid Contract, and write the number 4 in front of it, because there are 4 of them. And then we're going to highlight next to each number there in that list, just the titles, competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. All right, so as we get into each one of them, I just got into competent parties. It says in the book, to enter into a binding contract in New Jersey, a person must be at least 18 years of age and of sound mind. It goes on to say that a married person under 18 is considered an adult. No, they're not. Let me find, add more book manufacturer mistakes to my list. I need another page to add all their mistakes. Somebody under 18 years of age is not considered an adult, even though the book is saying that they are. That law was changed a couple, well, last year, early last year, or late the year before. We have a lot of child advocacy groups out there that were fighting to change this law, and they actually did change the law. This was put in place because because of various reasons, human trafficking, a lot of immigration from that we noticed coming into the United States, and from places where it is not uncommon to have what we'll call child brides, okay? So just because somebody's married does not make them an adult, okay? In New Jersey, it used to be that you could get married, and I don't know if it still is, but that you could get married as young as 16 with parental consent. and then you would be considered an adult if you're married, so you could sign contracts and such. But with the change of this law, I do not think that that's the case anymore, because of all the child advocacy groups. They fought for it that because somebody's a minor just because they're married, they're not considered adults anymore, so they cannot be treated like adults either. All right. Married persons considered adults. All right, so I'm gonna reach out to the book manufacturer about that one too. All right, so it says a married person under 18 is considered an adult. Persons under 18 may enter into a valid contract, but the contract is voidable by the minor until they become the legal age of an adult. All right. So basically what they're saying is that if you're under 18 and you're married, you're considered an adult. Anyone else that's under 18 that signs into a contract is not considered an adult and cannot. And if they do enter into a contract with you, if they don't want to be in the contract, they can just say, I don't want to be in a contract no more. And you cannot have a legally binding contract against the minor. However, the minor can hold the adults that they signed the contract with legally to the terms of the contract. Now, I know they changed the law. Like I said, I looked it up. I contacted an attorney on it. They said, yes, these laws have been changed, but how does it affect the real estate contracts here? If they're married, can they sign contracts in this regard? I really have to look into that more. But in the meantime, if you get a question on an exam about this, giving the answer option with if you're married and under 18, where you're considered an adult, just go with what the book says, okay? I don't think you would have that on the school exam, but if they ask it on the state exam still, then go with that. If they're married, then they would be considered an adult. Although I know they changed the laws on this, I don't know if they changed the exam on it. So go with what the book says, okay? Everybody got me on that?
Yeah.
So Victor, let's say that I have a 15-year-old son, right? Can I put his name on the deed?
Well, you could put his name on the deed, but he's not, you can't sign a contract. He can't sign a contract with me to buy my property.
Okay. So let's say that tomorrow, me and my son who's 15 years old is about to sell our house, right? So you come to my house and he has to sign it, right?
His legal guardian can sign it for him.
Okay.
When you're a minor, you have parents,
Okay.
or a legal guardian, somebody who's taking care of you. They would make the adult decisions for you. They could sign contracts for you. Look, if your son wants to buy my house and he's 15 years old, and I enter into a contract with him and I allow him to sign that contract to buy my house, right? Can I back out and say I don't want to sell it to him anymore?
Yes.
No.
No, I'm an adult. I signed a contract. I'm legally bound.
Oh, okay, I'm sorry.
The law can be enforced against me. However, if he says that he doesn't want to buy the house anymore, can I enforce the contract against your son who's only 15?
Not at all.
I cannot, because he's a child. He's not a competent party. And even though he was able to sign a contract and be in a contract, if he just says, I don't want to be in a contract, guess what? He's no longer in a contract. Okay? That's just, you cannot enforce a contract against a minor.
Got
it. Okay? Seen a couple episodes of Judge Judy that had things like that too, you know, where a guy, there was a kid, he was 16 years old, or 16 or 17 years old, something like that. He bought a motorcycle, you know, like a dirt bike, off-road dirt bike from a car dealer, and took it out, beat on it a little bit, rode it around, all that. And then decided he didn't want it back anymore. He didn't want it anymore. So he returned it to the dealer and dropped it off there. He said, I don't want it. And the dealer's like, you already took it out. You know, this is new. You took it out. You were using it already. It's like, you don't return this. We got a contract here. Went to court. The kid was very immature too. Went to court. Judge Judy went off on him just because he doesn't talk and shrug his shoulders. And you know how she hates that. So he went to court. He said the dealer said the story, what happened, like I just said. And then the kid said the story pretty much agreed with everything the dealer said. And then the Judge Judy, she said, so what's going on here? Why don't you want the bike anymore? And he's like, oh, I took it over for a ride, and I just don't want it no more. And she's like, so what are you saying? You don't want to be in a contract with him to purchase his property anymore? And he's like, and you know, she blew up on that. She's like, what's this? What's this? You know, say, what do you want? No, I don't want to be in a contract no more. And she's like, okay, case dismissed. And the dealer's like, whoa, what the hell just happened here? He just agreed to everything I said, and then you dismissed it, you know? So she walks back to the bench, and then she's like, sir, here comes her lesson, you know? She's like, you are an adult. You are a car dealer. This should not be your first experience with contracts. You cannot enforce a contract against a minor. This young man cannot even appear in court today without his mother, his legal guardian. Now, was she there with you? Did she sign the contract as well? Because if she did, then there's maybe something I could do, because we could enforce the contract if you had his legal guardian sign the contract as well. Did she sign it? No, only the kid did? Well, he's a minor. You cannot enforce a contract with a minor. You could be in a contract, but once he says, I don't want to be in a contract anymore, guess what? I cannot enforce a contract against the minor. Have to dismiss it. If he still wanted to be in it, he could enforce it against you, but you cannot enforce it against him. So, valuable lesson learned. Next time you enter into contracts with minors, make sure their legal guardians are present and have them sign the contracts as well, and then we could hold their legal guardians accountable. But until that happens, there's nothing I could do for you. Have a good day. Bye-bye. You know, and that's pretty much how it goes down in court. You know, can't enforce a contract against the minor because they're a child, right? All right, now, so competent parties is number one. That's adults and sound mind. You can't be in a contract with somebody who's their cheese is slipping off their cracker, so to speak. You know, so they have to be they can't be insane, Alzheimer's, dementia, drunk or high when you have them signing contracts. Okay. All right, now offer and acceptance is also referred to as mutual assent. This is when we have a meeting of the minds. Somebody has to make an offer and somebody has to accept that contractual offer. So when the parties are in agreement on all the major key points of the contract, or I should say all the terms of the contract, we have come to what we call a meeting of the minds. We're here, you know, we're in agreement on everything. That's a meeting of the minds, okay? Also referred to as mutual assent, but you're gonna see it on exams, if you see it on exams, as a meeting of the minds, okay? All the terms have to be clearly stated and understood by the parties. How could you be in a contract with somebody if you don't understand what the hell it was that you signed? Consideration, okay? Consideration is, well, first of all, consideration is the full purchase price. It's what the parties give or receive from each other in a contract, and it has to be something of value, all right? So it's the entire purchase price. Each party promises to give or receive something from each other. And here are three legal forms of consideration. Legal tender, that's money or a mortgage loan. An exchange of something of value. Good, whether it's goods or services. I will give you this in exchange for that, or I will do this for you in exchange for that, right? And love and affection. No, they're not talking about prostitution. Love and affection is a gift, for example, where the parties, all they expect in exchange for each other is to have love and affection for each other. Courts do value the relationships between parties as a legal form of consideration. A parent can give the property to a child because they love them and they have affection for them. And so that is the form of consideration. However, if that's the case, then it should be accompanied by a letter that states that it is, in fact, a gift. Okay? And lastly, legality of the object or purpose of the contract. Contracts have to be for a legal purpose, okay? It cannot be for an illegal purpose or for a substance that is illegal. Like, we cannot have a valid contract to sell drugs that are illegal, you know? You can't have a valid contract to sell crack, right? Crack's an illegal substance, right? You can't have a valid contract to kill somebody because murder is illegal, right? So these would not be valid contracts. It cannot be against public policy, okay? So legality of the object or purpose of the contract. It may not involve an illegal purpose or substance or object. It may not be against public policy, okay? So let's back it up again. What are the four elements of a valid contract? Competent parties, offer and acceptance, consideration, and love and affection. Oh, I'm sorry, consideration and legality of the object or purpose. All right. Now, what are the three legal forms of consideration? Legal tender, exchange of value, something of exchange of value, and love and affection. So we kind of learned two things there. The four essential elements of a valid contract: competent parties, offer and acceptance, consideration, and legality of the object or purpose of the contract. And you can apply these four essential elements to anything. An employment agreement, right? You go to get a job, you sign an employment agreement. Well, first of all, don't you got to be of legal age? Somebody has to make you the offer of employment, and then you have to accept it. What are you getting in a return for working, for doing this job? You're going to be paid some way. That's the consideration. And then what exactly are you doing for this job? It has to be legal, right? So you see, you could apply this to any contract, even an employment agreement. All right, not just purchase contracts of real estate. All right, now under consideration on number 3, highlight on the third line there under consideration. Consideration may consist of legal tender, an exchange of value, or love and affection. So that's the 3 forms of consideration. Now, after those 4 points in that list, highlight the next sentence that says a valid contract may be oral or written, and the parole evidence rule states that a valid contract takes precedence over verbal agreements or promises. Basically, if you got 2 people that got a contract with you, one says, well, we entered into an agreement, but I just don't got it in writing, and another one got it in writing, the court will dismiss the one that's verbal in favor of the one that's in writing. That's the parole evidence rule, because you have evidence, right? Your evidence would be the contract in writing, okay? Even though verbal contracts may be considered legal for some things, but not for real estate, even though verbal contracts may be considered legal for some things, if 2 people, look, if I'm selling you my cell phone, okay, I'm going to sell you my cell phone. Can we have a verbal contract in place where I'm going to sell you my cell phone? Yes, we can. And then if I enter into a contract with somebody else and I put it in writing, and now you say, wait a minute, you offered it to me first, and we get into an argument about it, you decide to take me to court, you don't have anything in writing and this other person does, the judge will kick out the verbal contract in favor of the one who's got the evidence, the parole evidence rule. That's basically what it is. All right, makes sense? Everybody good? You following? You understanding?
Yes.
Okay.
Yes. Yes.
All right. Want to make sure even though that I may not be able to see you, that you're not sleeping on me. Resting them eyelids. All right, so the statute of frauds, thank you. The statute of frauds. Okay, another term that we need to know, statute of frauds. We will highlight the statute of frauds. Basically, anytime you hear the statute of frauds, it requires something to be in writing. So let's highlight the first sentence here under statute of frauds. And statute of frauds states that contracts for the sale of real estate and any lease more than 3 years must be in writing and signed to be enforceable. I like that. Now, in most other states, the statute also requires the same thing, okay? Now, I want you to write something at the end of this line. I want you to write, leases longer than 2 years may be recorded. So the statute of frauds, as you see in this slide, real estate brokers authorization required for listings, okay? Basically, we need to have something in writing when it pertains to real estate. It must be in writing and signed by the consumer. No signatures, no witness signatures are required for the contracts to be valid. It applies to the sale or lease contracts, no matter who the broker is acting for, whether it's the seller or the buyer, the landlord or the tenant. Now, statute of frauds says that sales contracts for real estate must be in writing. When we're involved, whether we're involved or not, contracts for the sale of real estate always have to be in writing. However, leases do not. If there's no licensed real estate agent involved, because remember, we as licensees, we not only follow regular contract law, we also have to follow real estate licensing law. And what does real estate licensing law say? When it comes to us signing contracts with people, we always need contracts to be in writing. We cannot have verbal contracts with people. So it says leases must be in writing if they're 3 years or longer. However, if you're signing a lease with a licensee, it has to always be in writing. No matter if it's a week-long lease, right? Now, leases can be recorded if they're 2 or more years. That means that they can be added to the public record. They can be recorded in the public record, okay? Now, it's extremely risky to rely on verbal contracts, oral agreements for leases, so they should always be in writing, but it's not required if the lease is less than 3 years. And of course, a real estate licensee is not involved. We can't get paid on a contract. Licensing law says that, first of all, that we can't get paid on a contract unless we have it in writing. So real estate licensees also follow real estate law, which is what? 4515, Title 45, Chapter 15, and the Real Estate Commission rules, Title 11, Chapter 5, that state that we must always have contracts for sales or leases in writing, and we must never take verbal contracts. Now, can we get a listing agreement verbally?
No.
No,
Yes, we can.
you can, but you have to get the contract.
But we got to follow up with getting the listing agreement in writing within 5 days of that verbal agreement. You guys recall that now, kind of a little vaguely?
Yep, yep.
Okay. And then
But
I
it's
told you guys never do that, because remember I told you the story, the husband and wife went away for the weekend. I took the listing, I put it in the MLS, and then I was going to follow up with getting it in writing with them, and then they decided they're actually going to list it with their friend, wife's best friend who just got her license or something, you know? So I suggested you never do it in writing, even though we're allowed to. Real Estate Commission rules allow us to get a listing in writing, provided that we follow up with, without a verbal agreement for the listing, provided that we follow up with getting it in writing within 5 days and provide that owner with that copy of that agreement in 5 days. But then if we're going to be putting it in the MLS rules are when do you need to put it in the MLS, and when does the MLS need the paperwork? Within 48 hours.
48 hours.
Yeah. All right, types of contracts. Types of contracts, okay. Contracts can be, well, let's see. Contracts can be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. And we're going to go over all these terms right now. Actually, what I want to do is add one more slide in here. Let me duplicate this slide, duplicate slide. And on the first slide of this, we're just going to go over, we're just going to write down that little list that they have there. It basically says, you know, contracts can be. Contracts can be. And what can contracts be? Contracts can be express or implied. They could be unilateral. Oop, one T there. Or bilateral. They could be executory or executed. And they can be valid, void. Actually, I should say valid, void. Uh-oh, what the hell just happened? It can be valid, voidable. All right, let's say unenforceable first. Yeah. Valid, unenforceable. Voidable or void, okay? Voidable or void. So I'm going to have just one slide with just that stuff on there. Okay. So contracts can be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. Now we will learn what these terms mean. All right. And then we go to the next slide. There we go. So, okay. Boom, boom, boom. Can you guys see the slide?
No,
No.
not yet.
Not yet.
You cannot see the slide. Damn.
Yeah.
All right. How about now?
Yes.
Yes.
Every time I back out to minimize it, apparently you guys can't see it. And then I go back into it big again, and you still can't see it. I have to manually share it. Okay, so here we go. Making mental notes, talking out loud. All right, so contracts can be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. Now we're going to learn what these terms mean. And let's start with express contract. An express contract puts the contract in words, okay? It lays all the terms out in words, leaving nothing to interpretation, okay? So express contract is one that is expressed in one's words rather than their actions, okay? In their words rather than their actions. So it's usually in writing. I know I minimized that again. Hold on. I'm going to say usually in writing. All right. Go back to full screen. Let's go back to share. All right, so I just modified the slide a little bit. It lays out all the terms. It lays out all the terms, expressing them in words, leaving nothing to interpretation, usually in writing. Implied contracts are demonstrated by one's acts and conduct rather than their words. Therefore, it may leave things to interpretation. And here's some examples of an express contract. A lease that expires and the landlord still accepts the rent from the tenant. Well, what does that mean? If the lease expires, what does that mean? Is the landlord allowing them to stay there according to the old terms of the contract, or their new terms, or are they month to month now? How exactly does that work? Okay. Well, if the landlord accepts the payment, okay, even though the tenant did not sign a new lease, if the payment, the actions of the landlord taking the check, the payment from the tenant, in the eyes of the law, it creates an implied contract. It implies that the landlord's okay with that tenant remaining there now as a month-to-month tenant. And what about all the terms of the contract? Is that a little sketchy? Well, yeah, because nothing was said. So it leaves some things to interpretation. It's always better to have things in writing. Now, if here's another example. If a bank accepts a payment from an owner after the foreclosure process begins, it could be interpreted by the courts that there is some sort of a agreement between the lender and the owner for some kind of a repayment, that they were not going to come through with the foreclosure. And therefore, the judge may kick that out of court if they become aware of it, that the bank cannot go through with foreclosure. This is why when you're behind in your mortgage payments and the lender does collection calls, those calls will eventually stop. When those calls stop, can you make a payment today? Any payment, you're behind. Those payments will eventually stop. And when they stop, even if you were to call the bank, they would not accept any payment from you unless you could pay the full outstanding amount, including any legal costs and penalties and etc. Interest, to get totally caught up. If you cannot, if they accept any kind of payment from you, it can be interpreted that there is some sort of an agreement. When you go to court, you could be like, oh, but I thought that they were going to allow me to make payments as I could to get caught up. I mean, they did accept the payment from me. The judge would be like, what? They accepted a payment. Do you have proof of this? If you do, the judge would kick it out, because it seems like there is a possibility that that could be the case. It's implied. Otherwise, they would not have taken a payment. Contracts can also be unilateral, and a unilateral or bilateral. A unilateral, uni meaning one. Only one party is obligated to the contract, but only if the other party acts. So one party is obligated to do something, but only if the other party acts. So a contract where one party has an option to act or not is a unilateral contract. These contracts must only be prepared by attorneys. We cannot prepare option agreements, any contract that has an option in it. An example, a lease with an option to buy. We can prepare leases, but we cannot prepare the option to buy. Option contracts have to be prepared by attorneys because they could get complex, and we need to know the law in order to prepare them. So if a statement, if this statement applies, then it's a unilateral contract. I will do this. So this is the litmus test. I will do this if you will do that. If you could apply that to your situation, I will do this if you will do that. Well, that if is an option. So therefore, this is a unilateral contract, right? Now, bilateral contracts, on the other hand, both parties promise to do something in the contract. And their litmus test is, I will do this and you will do that. Both parties are obligated to do something. Not obligated to do something, but only if somebody does something. That would make it a unilateral contract. That would be an option if it says if in it, right? We good on unilateral versus bilateral?
Yeah.
So repeat that again. So unilateral contract.
Unilateral contract.
When someone is already agreeable.
Well, it's when somebody has an option.
Both sides.
when somebody has an option to do something according to the terms of the contract. In other words, you have a lease with the option to buy. Do you have to buy?
No.
No, that's an option. Well, that would be a unilateral contract because one party.
Mhm.
Now, is the seller obligated to sell to you if you exercise your option to buy? Yes, they are. So one party is obligated and the other one has an option.
Mhm.
So the seller's obligated to sell to you, but the buyer's not obligated to buy.
You're right, but the bilateral contract could be also
A bilateral
both.
contract would be just a straight up sales agreement. I'm selling you the property and you're buying it.
Mhm.
There is no option. Okay, so we're going to get into, look, you have a lease with an option to buy, and then we also have lease purchases. You're going to lease, and you're definitely going to buy at a time in the future. A lease purchase would be a bilateral contract because you're going to start leasing now for a certain term, and at the end of that term, you're definitely going to buy. Versus a lease option where you're leasing from me and you have an option to buy at a predetermined purchase price by a predetermined deadline, but you're not obligated to purchase it. In a lease purchase, you are. A lease option, you're not.
Mhm. Okay.
Okay.
Thank you.
Welcome. Now, contracts can also be executed. The term executed means signed. Okay. So executed or executory is referring to the current state of the contract, the status of the contract. Has the contract been executed yet? What am I asking? Have you signed it? Right? Now, fully executed has two definitions to it. It could mean, has the contract been signed by everybody? Or it's a contract where all the terms within the contract have been fully performed, they've been fully carried out, and there's nothing left to do. All the terms of the contract have been fulfilled. So they fulfilled all their contractual obligations, there's nothing left to do. The contract is fully executed. It's been fully executed, right? So it depends on how you use it in a sentence, basically. Now, the term executory, tory, meaning in progress. All the terms have not yet been fulfilled. So the contract's still in progress. There's still things that need to be done. So an executory contract is a contract where all of the obligations have not yet been performed. Make sense? I never heard this word used in the real estate business or by an attorney ever. Executed, fully executed, you're going to use those terms yourself. Other agents are, attorneys are. These terms are common. Executory, not so much. And fully executed, this number two option, this other number two meaning, we rarely will hear that used in actual life. But usually when we hear fully executed or executed, we're talking about signatures, okay? But I'm just saying it has a separate legalese meaning to it, okay? But it depends on how you use it in a question or in a sentence. So you don't gotta stress on these much. Studying wise. All right, now contracts can be valid, voidable, unenforceable, or void. Okay, now this refers to the status of contracts as well. What is a valid contract? It's a contract that it meets all the requirements to be enforceable. So what are the four essential elements of a valid contract? Competent party,
Competent parties, offer
offer
and
acceptance,
consideration,
consideration,
and legality of object.
and legality of the purpose of the contract or the object of the contract, right? So if it meets all those requirements, the contract's valid. Now, so if it's voidable, that would mean that one of the parties can disaffirm the contract. So there's something that's not necessarily 100% valid about this contract. However, a contract, an example is a contract with a minor. You can enter into a contract with a minor, but it cannot be enforced against the minor. So can't that minor, is there that possibility that the minor can disaffirm the contract? The underage person, the minor, isn't it possible that they could disaffirm that contract? Yes.
Yes.
So one of the parties can disaffirm that contract. So therefore, a
But
contract.
if they
with a
had
minor-
a parent
Well,
be there and present, then that makes it legal, right?
then it's not voidable.
Then it's not avoidable. Got
It's
it.
not voidable. And then it's still a valid contract. A voidable contract, the key to it is it may be disaffirmed by one of the parties. And this is always going to be an exam question on school and state exam. And they usually bring up the case about a contract with a minor being voidable. They may come up with another wacky one, but the one I've always seen was contract with a minor is an example of a voidable contract. It can be disaffirmed by the minor, right? Or how about this? How about two guys are hanging out and one of them wants to buy the other guy's property and he's willing to sell it to him. But they were both drunk at the time. And then when they both sober up, they still want to go through with the contract. Is this contract voidable?
No.
No.
Well, the difference.
I mean, yes.
Well-
yes, but they still agree. So
Well-
it's gonna go. It's in.
Okay, so let's evaluate what just happened there. You got two guys are drunk. They're both drunk. Neither one's a competent party at the time that they signed the contract, right? But if when they sober up, they decide they still want to go through with that contract, the contract is known as being valid between the parties. And they could go forward with the contract and it would be valid. However, neither party can sue to force performance because neither party was competent at the time. Remember, a voidable contract is where only one of them can disaffirm it. Whereas an unenforceable contract, neither party can sue to force performance. So when both parties are incompetent, it's unenforceable. If they choose to go through with it, they can, but it would be valid between the parties only.
Until they both sign it when they're sober.
If they've signed a new contract when they were sober, yeah, that would be the wise thing to do. If you want it to be a valid, legally binding, and enforceable contract, yeah, then you would do that. You'd have them sign a new contract when they're both sober. Right? And a void contract is kind of a self-contradictory term because a void contract isn't a contract at all, right? So a void contract cannot be enforced by either party because it's already been canceled. The contract's been canceled, or it's missing essential elements that would make it legally enforceable in the first place, all right? So the example with the two drunk people, it's valid between the parties. Unless they don't want to be in it no more, then it's void, right? A contract with a minor, it can be valid as long as the minor wants to be in it, but if the minor backs out, guess what? It's void, right? A void contract is basically a contract that's, it can't be enforced. It's been canceled already because it's missing one of the essential elements. All right. So the ones that you usually get on exam for this though, voidable. A contract with a minor is an example of what kind of contract? Voidable. Okay. Or an example of a voidable contract would be Joe Smith signs a contract to sell his mobile home to Billy Bob, who is only 16 at the time that he signed the contract, right? There you go, there's your example. Now contracts can, validity issues can pop up too. Undue influence means that you're being taken advantage of. Now, to be valid, every contract has to be signed as the free and voluntary act of each party. So you must use extreme caution when dealing with elderly people, those who are under the influence of drugs or alcohol. Sometimes that can be difficult to tell. You have functioning alcoholics and people who are always stoned, right? So it could be a little difficult sometimes to figure that out, or to find them when they're sober. So you have to be aware of mental disease and defect. I mean, how are we going to do that? That's going on inside their head. We just need to observe people well, all right? Observe people's actions, observe people, how they're acting, and even then you don't know. Observe their speech, ask them questions without being rude though. When dealing with elderly people, you don't want to be rude to them, assuming that because you're old, your cheese is slid off your cracker and you're kind of insane, you don't know what you're talking about, or you're out of your mind, all right? Not all old people have dementia or Alzheimer's, but look, you could have somebody who's perfectly lucid. They're sharp as a tack on issues. They could have a conversation, a very intelligent conversation with you. But then something comes out of that conversation. They think they're in 1940, There's your first clue that there may be a problem. So even though they could have that perfectly sharp conversation, if they don't know what time that they're in, what year it is, they may not be of sound mind right now. So you can't get into a contract with somebody like that. Now, duress means force. You cannot force somebody or use threats, intimidation, or bribery to get them to sign a contract, okay? Now, undue influence could also be getting somebody to sign a contract that's on their deathbed or in a hospital. They're under great distress, right? Use extreme caution if anybody's signing contracts when they're in the hospital and they're on medication, they're on their deathbeds or whatever. You should have an attorney involved in that, because even when there's an attorney involved, those can be disputed, right? You'd have to have it established that their mind is sound, but then still, with the stress, somebody can argue, how could you say that somebody was of sound mind when they think that they're going to die, So there could always be an argument comes out of it, so let the legal experts deal with that, okay? I wouldn't go getting people signing contracts when they're on their deathbed. Not exactly the best thing to do, all right? So let's get caught up in some highlights. Express on page 169, express contracts. We're going to highlight express contract. The parties state the terms and show their intentions in words. Then a line below that, we're going to highlight implied contracts, and then go to the end of the line and highlight is demonstrated by their acts and conduct, their actions. Then under bilateral and unilateral contracts, on the second line, we're going to highlight bilateral contracts. Both parties promise to do something. If you wanted to highlight or underline the litmus tests, at the last line in that first paragraph, it says, I will do this and you will do that. Okay. And then the next paragraph, we're going to highlight a unilateral contract is a one-sided agreement whereby one party makes a promise to induce a second party to do something. The second party is not legally obligated to act. However, if the second party does comply, the first party is obligated to keep the promise. Did you follow the bouncing ball on that one? Okay. Yes, I think the slides that I gave, that my explanation was a little bit less, trying to figure out, reading it 10 times what the hell they're talking about. Basically, one party's obligated to do something, but only if the other party acts. Okay, now, and who has to prepare those contracts, or who can prepare those contracts? Let me see. We didn't have that in there, dude. An option contract is generally unilateral. The buyer optionally pays for a fee. Well, I want you to write at the end of that, one for unilateral contract, at the end of that paragraph, I want you to write, must be prepared by attorneys. Must be prepared.
What about the bilateral? Did they have to be prepared by attorney as well?
No. Can you write a sales contract?
Yeah.
Sure, for 1 to 4 families and single residential buildable lots, you can. For sale and for lease. Right? We just can't do it for commercial properties. We can't do option agreements. Okay? Certain contracts we can't do because it requires a bit of additional legal knowledge. Okay. First of all, any contract has to have something of value given in exchange, right? That's called the consideration. What's the consideration for an option? You're giving somebody the option to buy. What's the consideration that makes it legal now? See, you need a little legal knowledge for that, okay? Now, it could be they're paying an additional rent. They're paying, so they're paying a higher rent to get that option. Well, that higher rent do they get that money back if they don't exercise the option to buy? And if that's the case, do they get an interest on that? Or does the seller get to keep that additional rent, whether they exercise their option to buy or not, just as additional rent? See, this would all have to be put into a contract, and an attorney would address those issues, and they would know which, what's legal and what's not. Do you know if any of those would be legal to do in New Jersey too? So you got to know the laws. So this is why we do not prepare option contracts. They start getting a little more complicated, and you really need to know the law in order to do that. All right? All right?
Yes.
Okay. Okay, so, and then under executed and executory, just highlight a fully executed contract is one where both parties have fulfilled their promises and thus performed the contract. And an executory contract exists when something remains to be done by one or both of the parties. Okay. The last 2 lines in the next paragraph for it, I'm just going to put a little star next to it. It's basically talking about the difference between fully executed and executed, and their alternate meanings. It's just a signed contract. Fully executed contract has been signed by everybody, or it can mean a contract that's been fully carried out. All the terms have been fully carried out, and there's nothing else left to do. Now, under validity of contracts, just go to voidable and highlight voidable contract, and then go to the second line and highlight, for example, a contract entered into with a minor is usually voidable. You're always going to get a question on that on exams. Turn the page. You got your undue influence and duress, just understanding them. So nothing really to highlight there, but I'll put a little asterisk, a little star next to the title, undue influence and duress. And then we get to the next issue. Performance of a contract. Well, we have dates in contracts. Courts have ruled that dates that are put in contracts are merely guidelines that are to help people follow when things should be done by. They do not consider somebody to be in breach of contract if they miss one of those dates. Those dates are not deadlines. They're merely guidelines. That's the way the court looks at it. Courts look at dates in contract as merely guidelines, not deadlines. So therefore, if you miss a time, a date in a contract where something should have been done by, You can't be like, oh, you're in breach of contract, I'm suing. Because the courts only look at dates as guidelines. But sometimes we want those dates to be solid, to have meaning to them, that we want them to be that you are in breach of contract if you miss a deadline, right? So we want these hard deadlines. And a hard deadline would be when we use a term that's a legal term called time is of the essence, meaning it's very important. Time is very important. So this terminology should be left to the attorneys to use. I usually would ask the attorney to use it, okay, but I don't use those terms. I won't put a time of the essence order in any contract or in any correspondence. I would call the attorney and ask the attorney to issue a time of the essence order. Let them handle that, okay? This is legal stuff, and I don't want to get accused of practicing law without a license too. So it's a strict deadline that must be met, and any party will be in breach of contract if they miss the deadline. By the way, I keep saying breach of contract. Breach of contract means that somebody violated the terms of the contract without having a good legal excuse to do so. And therefore, they could be held liable financially to the other party. So a strict deadline that must be met, or any party will be in breach of contract if they miss that deadline. So we should leave this term strictly to attorneys to use. A time where we would usually use time is of the essence order would be if I am the seller's agent, okay? I'm the listing agent, right? I'm the listing agent. And a buyer, we accepted a contract from a buyer. And in that contract, it said that they were to, they have to give us a mortgage commitment letter by a certain date. Remember, I told you when they make an offer, first they reach out to a lender, and the first step is they got to get a mortgage pre-qualification. And then once they supplied all their financial information and such, then they work on getting that mortgage pre-approval. But that still doesn't mean that the bank's giving them the loan. Because once they still have to find a house, and the house has to appraise for the purchase price, can't have any major issues with it, etc. Has to, so once the bank has got the person's financial information and application and all the information about the property, and the bank is saying, or the lender is saying, we are without a doubt going to give you this loan, then they issue a commitment letter, a mortgage commitment letter, where the lender is committing now to give the loan. So we have dates in the contract that stipulate when that needs to be obtained by. And say that that date came and gone, and that buyer's agent never reached out to me and told me and gave me the commitment letter like they were supposed to, which you guys need to be cognizant of these dates, the important dates within a contract. Make sure that you're on the mortgage company and the borrower's case to make sure that they're doing what they need to so that they can obtain that in time. Otherwise, this contract will die. And I'm giving you an example of that right now. So they made an offer on that property. They were supposed to have a mortgage commitment letter from their lender by a certain date, and they don't have it. So I reach out to the agent, and the agent's like, "Oh yeah, I forgot about that. Let me call the mortgage rep, and I'll get them to send it over." Then you don't hear back. Yeah, I'm following up with you again. Where's that mortgage commitment letter? Are they having a problem getting the loan or something? Oh, no. They just needed to get something else, and then the lender was going to issue the commitment letter. They just needed something else. Yeah, following up again. Did you guys get the mortgage commitment letter? Oh, yeah, we're just waiting on them sending it to us. It's starting to seem like they're jerking me around a little bit here. Are they having a problem to get the loan? If that's the case, I'd like to know, is that agent, am I getting the feeling that agent's not being honest with me? Are they trying to shop with other lenders maybe because they're having trouble with this lender? So at this point, if I'm getting that feeling, I want to kill this deal and put the property back on the market so that we could get another offer on it that I know is going to go through. So if I think they're really jerking me around, that I don't think this person's going to be able to go through with the loan, I'm going to reach out to the seller's attorney, the seller's attorney, and have them issue a time of the essence order to the other side, saying that they must produce the mortgage commitment letter by a certain date and time. And if they don't, then the contract's automatically killed. No further communications need to be made. Contract's dead. I could put the property back on the market and we could find another buyer. Now, you must be careful. They refer to this as a two-edged sword, this term, because what if that date comes and goes and they did not produce that mortgage commitment letter? The contract is automatically killed, right? But
No.
what if the very next morning they have the commitment letter? They got it the very next morning. Well, contract's already killed. But can the attorneys piece it back together? Can they put the
Yeah.
contract back together?
Yeah.
Only, I think, if the two parties agree.
Yeah, they can put it back together if both parties agree to it. But wait a minute. Do they need to agree to it exactly the way that the terms were agreed upon before?
No, I think they could change it now at this
Yeah,
point.
look, because the contract's dead.
Yeah, they could.
I could agree to go back under contract with you, but you know what? I didn't like something with the deal before. Now, you could put your property back on the market again and start all over at square one, or we're already through attorney review. We got the mortgage commitment letter. We could continue on. You'll be much closer to closing, but I want to rearrange some of the terms of the contract here now. See, now the buyer would have a little bit of an upper hand there. So you got to be careful when using a time of the essence order. Okay? You got to realize that a double-edged sword can cut both ways. So let's highlight. Where do we highlight? Oh, under performance of the contract, page 170. On the second line where it says time of the essence in bold, we're going to highlight time of the essence means the contract must be performed within the time limit specified, and any party who has not performed on time is guilty of breach of contract. That means that they broke the contract without a good legal excuse to do so and can be held financially liable to the other party. Okay. Now, assignment or novation. All right, so these are additional things that are going to be coming up shortly. Performance of a contract, date guidelines, time of the essence. Well, we just did that. Discharge of a contract. Contracts can be discharged. We're going to go over the different ways that they can be discharged or canceled. What breach of contract is, I explained it to you already, but it's going to come up again. We'll highlight it. And then what statute of limitations terminology means and what the statutes of limitations are for certain contracts. We're going to go over. Now, assignment and novation. So that's the next paragraph here in the book, going along with these slides. When one party assigns their contractual obligations to another, but is never relieved of their obligations, they always hold the primary responsibility. And one example of this would be a sublease, right? If you're leasing a property from a landlord, now most leases have stipulations in them that a tenant cannot sublease to someone else. But if they allow it, if you're a tenant and you're renting, you're subleasing to someone else, if they don't pay the rent, are you still obligated to pay it? Yes, you are. Now, let me give you an example. I'm renting a commercial space right now. Let's just say that I found a building to buy. I need to get out of here, but the landlord won't let me out of my lease. But they'll allow me to sublet to someone else. So I get another company to come in and lease my space. So basically, they're pretty much taking over my contract, right? with the landlord. But the landlord's not relieving me. So I'm still under contract with the landlord, and then I'm just writing a new lease that I'm leasing now to the new tenant. It's a sublease. That's what they call it. Now, if that tenant does not pay me the rent, uh-oh, my power just went out. Can you guys hear me still? Hello? You guys there?